All rise. The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court. Now sitting.
Please be seated. Good morning and welcome to the Kansas Supreme Court. Want to do a special welcome. Looks like we have a very nice group, large group from Washburn University. Their intro to law class led by Professor Michelle Watson, a former research attorney of my chambers in this court, who we always love to welcome back. Professor, would you like to come up and introduce your class?
Good morning, Chief Justice and your honors. It's wonderful to be here this morning. I have a group of legal studies students, about 21 of us are here today, and either they're majoring in legal studies or minoring in legal studies, getting their bachelor's degree. And they also either want to go into the law and work as paralegals, or some want to go into law school and perhaps become a justice one day. But they're all very excited to be here and have never been inside the Kansas Supreme Court. So this is an honor for us. Thank you very much.
So for all the attorneys, the pressure's on today because our goal is to have every one of these 21 students end up with a career in the law. And we hope that they all aim for law school and this bench, because our profession has a epidemically growing, maybe a way to say it, shortage of attorneys. So let me assure you, there are jobs out there and opportunities, and we hope that you really enjoy today and learn from it. And we do nothing to quash your ambition to go to law, to go into the law. So with that, because these students and others may not be totally familiar with the procedures of the court, I might give a few explanations. As we start today's process, we have already, both the attorneys and the court, have already done a great deal of preparation and study of these cases. The court has received briefs as well as memoranda from our own staff about these cases. We have read those materials, we've read resources, we've read portions of records, and many other things to help us prepare for the arguments today. We now look forward to an exchange with the attorneys about the facts and legal issues in the cases. I will tell you that, as you might guess from having done that work to prepare, we have made notes and we have those documents in front of us on our computers or in paper form before us. So you may find us looking at our computers as we look at those notes or our papers. Please know that when we do that, we are doing it just to help us understand and assimilate the arguments that are being made and to help us process that. Our attention is still very focused upon the case and the matter that's before us. With that explanation, I will ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the 9 a.m. docket.
Thank you, Your Honor. The first case on the 9 a.m. docket for Wednesday, September 13th, 2023 is appeal number 124920. Shanna L. Jarmer versus the Kansas Department of Revenue, Sumner County, briefs both sides.
May it please the court, Ryan Gearing for appellant Shanna Jarmer, present, ready for argument.
Charles Bradley for appellee, KDOR, present and ready for argument.
Second case is appeal number 123687, State of Kansas versus Joshua F. Sinnard, Douglas County, briefs both sides.
May it please the court, Corinne Gunning of the Appellate Defender Office appears on behalf of Joshua Sinnard, present and ready for argument.
May it please the court, Senior Assistant District Attorney John Simpson appears on behalf of this plaintiff appellee, the state of Kansas, present and ready for argument.
Your Honor, that concludes our 9 a.m. docket.
Thank you, Mr. Shima. With that, I'll call forward the attorneys in 124-920, Shayna Jarmer versus Kansas Department of Revenue.
May it please the court, Ryan Gearing for appellant Shonda Jarmer. May I please reserve rebuttal?
3 minutes is reserved. Thank you.
Thank you. The issue in this case, your honors, is whether my client, Ms. Jarmer, was operating her vehicle or whether she was merely attempting to operate her vehicle. That's important in this case because in a civil administrative license action, according to KSA 8-1002, when we have a test failure, when the person's consented to take a breath test and has completed that, there must be actual operation in order for there to be any suspension or restriction of their driving privileges. The facts in this case are not in dispute. Ms. Jarmer was a passenger in a vehicle that was driven by her husband. He drove the vehicle to the point where the vehicle became stuck in a ditch in some mud, which is a little bit of a different situation than we sometimes see in cases where we're talking about attempted operation. Usually it's a situation where perhaps somebody is out on the side of a country road, law enforcement makes contact with them. They're not in the vehicle or asleep in the vehicle or you know, whatever the facts of those particular circumstances are. But in those situations, there's always circumstantial evidence that the person had driven or was attempting to drive the vehicle by nature of the fact that there's nobody else around. The vehicle got there somehow. And like I said, circumstantially, it appears that person probably is the person who got the vehicle to that point. So given that we know that she didn't operate the vehicle prior to it becoming stuck, we're left with whether she attempted to operate the vehicle after the fact. So when the law enforcement arrived at the scene where the vehicle was stuck, Ms. Jarmer was in the driver's seat. Her husband was behind the vehicle, trying to push the vehicle, trying to get the vehicle unstuck. She was pressing on the accelerator.
And the engine was on.
The engine was on.
Wheels were engaged.
Yes.
Transmission was in drive or
Yes.
reverse and trying to.
Yes.
Well, why isn't that operating?
I don't believe that that's operating, Your Honor, because by the definitions that have been provided by this court in various cases, and I'll start with State versus Fish, I guess, back in 1980, where this court said operate means drive.
Why isn't that driving?
Our position
Our
is,
definition.
our position is that it's not driving, Your Honor, because the vehicle isn't going anywhere. It's not moving. And I think that's where we get to State versus Kindle, which is a 2002 case. That's after the legislature had added a language to the DUI statute regarding attempt to operate. And this court said that the DUI statute encompasses both those accused of actually driving the vehicle under the influence and those who merely tried to drive but failed. So,
And isn't the intent there, though, that she was trying to drive?
yeah, we
The
admit,
goal was to get it out. And so does that intent play into the reason she got behind the wheel?
I don't know that intent matters, Your Honor. I think this is a situation where did she succeed in operating or did she merely try to drive but fail? And we admit that she did. She tried to drive. She just failed. And that's our position as to why this is an attempt to operate as opposed to actual operation.
Your
She-
position is that this factual scenario is, as a matter of law, identical to the case where your client gets behind the wheel, inserts the key, and the starter just fails. That-
ye-
There may be an attempt, but given the fact that the vehicle didn't move, it wasn't an actual driving.
right, I would agree with that, Your Honor. The reason for the failure, I guess, I don't think matters. It's
Right,
just
that's
a-
what I was getting at.
Yes, yes, Your Honor, thank you.
You think that there's any significance to the fact that under the suspension statute, attempt is insufficient, right? But under the criminal code, it is. And what does that mean? Does that mean anything in terms of how we define operate under the suspension statutes?
Obviously, Your Honor, there is a difference between the criminal DUI statute and the civil statute regarding driver's license suspensions. I don't know that it necessarily makes any difference what we're talking about, because we're still just talking about whether or not somebody operated or attempted to operate a vehicle. And obviously, under the DUI statute, it doesn't matter. Either one is sufficient. But under the statute regarding the driver's license suspensions, the legislature did differentiate. Test refusal, either one is sufficient, just like in a DUI case. But when there is a test failure, they did make that distinction.
You think it has no significance in terms of how our interpretation of the statute, specifically operation, and that we should adopt the same definition that we've applied to the DUI statute?
Yes, Your Honor, that's what my argument is.
Let me ask you this. The evidence in the record, does it show that the vehicle was kind of rocking back and forth?
I don't believe that there was any testimony ever that the vehicle was rocking, or I think the testimony was that the vehicle just never moved. It was stuck to the point where it wasn't getting out of there. The tires were spinning, like I said. The vehicle itself did not move or go anywhere.
So if I'm stopped at a stoplight and that's the only observation of me behind the wheel and I've stopped, engine's running, am I driving or I'm not? I'm not moving.
I would say, Your Honor, that at that point, you are not driving. But for purposes of what we're talking about here today, and especially in this setting, there would certainly be circumstantial evidence that you had driven.
No, forget, yeah, just the only observation is I'm stopped at a stoplight. And then there's, is that driving?
At that
Under
point-
under your definition.
At that point in time, I would say no. But like I said, and it kind of goes back to the example I gave at the beginning, have operate or attempt to operate. And I think under that circumstances, there wouldn't be an argument about whether the person had operated the vehicle, because circumstantially, clearly they'd driven the vehicle to that point.
Are you,
If nobody else is there.
are you relying on the language from this court's decision in State v. Darrow
Yes, Your Honor.
that states that operate requires movement of the vehicle?
Yes, Your Honor.
And so my follow-up is, I guess, absent that statement in Darrow, is there anything else in our case law that supports your position?
I would point back, I guess, to State versus Kindle, Your Honor, that talks about, driving, but you're right. Darrow is the case where it actually comes out and says that.
Doesn't Kendall say that nothing in Fish, the earlier case you started with, or other Kansas law, says that the definition of driving does not require movement?
Right.
Which is kind of a statement in the negative, which doesn't get us all the way there, does it?
I agree with that, but, and I think.
It's really Darrow.
Right, and that's where we get to Darrow, which, like Your Honor said, it says driving requires movement of the vehicle, and therefore operating requires movement of the vehicle. An attempt to operate means an attempt to move. I think what we have in this case is Ms. Jarmer was attempting to move her vehicle.
Is there any, let's just say for purposes of my question, that upon further examination, that statement in Darrow seems to be overbroad? Is there any stare decisis rationale for sticking with it?
To me, Your Honor, drive means that you're that you're going somewhere, like I'm driving to the grocery store. You know, if I'm sitting in my driveway with a vehicle on, I'm not driving at that point. And I think that's something else that's important is, you know, obviously in this case, the vehicle's on, the transmission is engaged. You know, all of those things are there, but generally in situations where we have people asleep at the wheel or any of these other things, the court has always looked at the fact that the vehicle's on, these other factors as factors in whether the person was attempting to operate the vehicle, not just that you have control of the vehicle and therefore you're operating the vehicle. And also I think that that's important. Another important thing from the Darrow case is that it says that taking actual physical control is insufficient to establish attempt to operate a vehicle without an attempt to make the vehicle move. And we know from that case that Kansas isn't an actual physical control state. Some of the other states around us are. And
Just to summarize, it sounds like you want to plant your flag on Darrow was right.
yes, Your Honor,
And
I think Darrow
there's
was
no
right.
reason to depart from it as opposed to stick with it, even if you have questions about it.
I think that Darrow was decided correctly, Your Honor.
So the operative word is forward, because clearly the vehicle was moving. I mean, the vehicle, the engine, the tires, all the component parts that would be moving if I'm not at a stop sign, but going down the street. All of that was going on, but probably, and I would concede, not going forward. Or let's presume it was not going forward. So it all rises and falls on whether or not it's actually going either forward or backward.
I would agree with that, Your Honor. I think the vehicle has to be moving or traveling, going somewhere. Because obviously if a vehicle is.
I mean, it's doing everything else,
Right.
right? It's just not going forward or backward.
Right. I mean, the vehicle is turned on. Obviously, anytime a vehicle is turned on, there's parts of the vehicle that are moving. And I think that in the cases that we're talking about, the court never says that the parts of the vehicle are moving. It's the vehicle itself that has to be moving in order to drive it.
How about if the car was rocking? I'm actually just envisioning the next case, which is car was rocking, they couldn't get out of the ditch, and the argument that you would be making is, well, it was the husband from behind the vehicle that was making the car rock, not your client behind the wheel gunning the engine, spinning the wheels. And so we've got to make that distinction too.
Sure. And I don't know what the right answer is on that, Your Honor, to be honest with you. It's not the facts that we have here.
You need the chassis to travel one direct, either forward or backward.
Right. And that's right. Your Honor. Our position is, like I said, I guess the example that I would give is, you know, when I think about driving, it's like, I'm going to drive to gas station. I'm going somewhere. The vehicle is traveling from point A to point B. And whether it's a foot or 10 miles or whatever, we've got to be driving. The vehicle has to be moving. And I think that that's what the intent of the cases that we've been talking about.
Let's talk about the intent of the legislature, because we don't have a lot of definitions here. You know, if she wouldn't have if it wouldn't have been stuck. I mean, the whole point is that, you know, you don't want people who are under the influence of drugs or alcohol to be driving. And in this instance, it was just by the, you know, to draw a line, to plant your flag on this moving. And the fact that we said that in Darrow about the moving, isn't that really, does that further is that really the legislature's intent here? To draw a line on that moving? Is that what they meant?
I mean, it's hard to know exactly what they ever mean, but the only thing that I know is that they did make a distinction. In that distinction, it doesn't, you know, there's no guidance as to why.
Well, wasn't the distinction made because actually, in our case law, I'm pretty sure that in State v. Kendall, after that happened, that's when they amended the criminal statute, these are all in context of criminal statutes.
Sure.
Right? And so they amended the criminal statute, say, okay, to include attempted. Because these cases were arising not under the driver's license umbrella, but under criminal cases. So I'm not sure that the legislature's intent to make the driver's license cases different was based on, you see what I'm saying? I mean, we had this line of cases in the criminal
I do.
context.
I do understand I guess the way that I would answer that is, obviously at some point, I don't remember the year, the legislature changed the DUI statute to prohibit both operating and attempting to operate. And given the language in the suspension statute, that statute had to have been written after that because the attempt language is contained in the suspension statute also. So I guess the best way to answer your question is they did make a distinction where people who are attempting to operate a vehicle don't get their license suspended. Purpose of that, I don't know. But like I said, I'm not sure that the reason for the failure matters. I think this just comes back to, did the person operate or did they attempt to operate?
Have we made this way more complicated than it needs to be? We meaning appellate courts by really trying to parse through all these various hypotheticals, and why isn't this just a plain question of fact?
I really don't know the answer to that, Your Honor. To me, it seems simple. I mean, it's either you're driving or you're trying to drive, but you failed. I mean, it's one or the other, right? That's the way that I look at this. So when I look at it, to me, it seems very simple, but I understand there's more to it than that. Thank you.
Bradley?
Charles Bradley for Kansas Department of Revenue. Thank you, Your Honors. I guess just to paint a picture for everyone in the room, back in January of 21, law enforcement was called to scene of an accident wherein a vehicle had driven through a few yards and was stuck in a ditch. Upon arriving, the officers saw that there was presumably a husband trying to push from behind, and the wife was in the driver's seat, revving the engine, spinning tires, etc. I did question, and the officers testified that they did not witness the vehicle propel forward or backward. They did not witness the wheels, the steering wheels turn. They're not saying that it didn't happen, but they were very clear about what they
Clarify that,
witnessed.
it's the steering wheel or the wheels in the ditch?
Both. I asked about the back wheels. I asked about the front wheels.
Fine, okay.
I wanted to get a
clarification.
very clear picture of anything that moved. After they questioned the couple, they believed their statement and understood the husband had driven to the location in order to get it out. Husband gotten back, Ms. Jarmer got in the driver's seat, and they were trying to get it out. And Jarmer was arrested for DUI, produced a breath test of 0.156, and issued the license suspension. Under KSA 8-1002, if a person fails a test, there has to be operation of a vehicle, not just an attempt.
And if the legislature had just added the phrase or attempting to operate, don't even have to stand up at the podium, do you?
I don't. However,
but from a textual point in this statute, just looking at the text, the fact that the legislature didn't add that provision has got to mean something, right?
does. And while I wasn't there for that, generally the intent on that bifurcation is to protect those that decide to, what we call sleep it off. You come out of the bar, you're quite impaired, you turn on your car and you pass out. That is an attempt under the current case law. A person that does that will get arrested for DUI, but won't lose their license as long as they submit to testing. If they're cooperative, if they made the right choice and didn't actually put it in gear, they're probably going to walk away with a diversion.
So, I'm looking at this now and I don't think I noticed this before. So the legislature has made a distinction in driver's license cases regarding the officer's certification, whether the driver failed the test or refused the test. If the driver fails the test, then you got to show operating. If the driver refuses the test, you got to show operating or attempting to operate.
Correct, Your Honor. We have less sympathy for those who refuse testing.
Okay, got it.
Counsel, if I could draw your attention to the language in our case law that I spoke with your colleague about, specifically State v. Darrow. Do we have to overrule that language from Darrow in order for you to prevail?
Not at all, Your Honor.
Why
And
not?
Darrow is a fantastic case. It goes into a lot of explanation about what goes on in a criminal case. However, as explained in Aaron's, there we are. Aaron's was actually before Darrow, but after Kindle. And it kind of helps explain the criminal cases need to be taken with just a bit of a grain of salt, not assault, salt. In criminal cases, it doesn't matter whether there is attempt or operation. So when they discuss a distinction between the two of when does attempt become operation, it's basically dicta. It's not useless. It's logical.
Well,
But
I'll draw your attention to the sentences that seem to stand for a pretty bright line rule that, quote, operating requires movement of the vehicle. Got to move the vehicle to operate it. That's the pretty bright line statement from Darrow.
Darrow also said that engaging the transmission is the last step before driving. Or
I'm just asking you to help me
I
understand how you win when that language is there. Would we at least have to say Darrow was wrong in that limited sense? Maybe we call it dicta, what have you, but
I would say that its application, especially in the instance of 8-1002, which is very specific on operation, is more limited. It's not wrong, but more so that points out what movement and operation is. The court in this case found movement. The vehicle moved in so many different ways. There was just not forward propulsion.
well, there was movement of parts within the vehicle. Is that what you're saying?
Correct.
So I'm mechanically inclined. I like to spend my Saturday afternoons tinkering in the yard. I've got, my hot rod up on jacks and I'm having a few beers and I'm, messing with the engine and I turn it on and I'm revving it up and the transmission's engaged, the wheels are spinning, what have you. And I'm over the limit. Like, did I just violate the statutes?
Actually, that transitions to a fantastic case that I wanted to bring up, the Cullison versus Kansas Department of Revenue. And that one actually matters because it is a license suspension case. In that case, the gentleman was straddling his motorcycle, revving the engine, and he was actually moving back and forward, waddling it. But the transmission was missing bolts. It couldn't even be engaged or used. And in that case, the same Chief Justice that decided the case below us said that's not operation. Because there's no way that this vehicle could move.
How does that, that seems to cut directly against you. Because the analogy would be the mud acts like the missing bolts to prevent movement.
It cuts against a bright line rule. And that's really the main thing that I'm trying to propose today. The rule of thumb that movement equals operation is fantastic for most law enforcement. If you see a vehicle driving down the highway, all right, I can check operation off.
Why shouldn't we just say operate is a common English word? Juries, fact finders, they're pretty smart generally. They understand language. It's a fact question. Leave it to the fact finder.
I completely agree with that. And the fact finder here found that that was movement. And he did so in a very reasonable manner, I believe. But the main thing was that we would like to move away from a bright line rule that says movement is required and movement equals operation, because it doesn't always. You can have operation without movement. You can have movement without operation.
But how does that give guidance to our law enforcement officers out there?
It really doesn't, and I feel sorry. The rule of thumb that movement equivalent to operation would take care of 95% of the cases. This is a very specific case that has not come up before in our case law. Attempt and operation doesn't matter for the arrest at the time. The only distinction is made after the arrest, after the breath test, and whether they're checking off which box on the DC-27. So in reality, this probably isn't going to come up very often. But what I want to establish is that there is no bright line rule for operation, that it needs to be reasonable in this thing. It needs to be based on the fact finder. It needs to be within the discretion of the court to determine, was this vehicle actually being operated, and use all the different factors. And that's what the Court of Appeals pointed out, is that there are a lot of different things to consider. You should look to see, was it the actions of the person in the driver's seat that were operating? Was it outside environmental conditions that were preventing operation? And that was one point that the district court clarified, was that he could not simply find that because of the conditions that the vehicle was in, that being the muddy, soft, wet yard, that these acts on behalf of the driver should not constitute operation of the vehicle, movement of the vehicle, and driving the vehicle. Now, I'm sure that the court would love to have a clear definition of what operation is, and I'm sure law enforcement would as well. And like I said, the element of movement certainly helps that.
Let me ask you, I'm still struggling, so I'm looking for something that people can understand. The phrase that's in the Court of Appeals decision, Jarmer was, and then the phrase is actual physical control of the movements of the machinery of the vehicle. Okay, if that's the test, that gets you where you want to be, where the department wants to be. Why not?
Admittedly, because Kansas has intentionally pushed itself away from the term actual physical control. I believe that was referenced because of their, they looked to other states with similar cases to see if their logic was, I guess, congruent. I will point out that they did not rely on these outside cases from Missouri and Pennsylvania as binding precedent. They came to their own decision. And then at looking at similar, almost identical cases from other jurisdictions, they saw, okay, but even though their statutes may be a little different, most states do not bifurcate between operation and attempted operation.
Then how do you articulate the test that the department wants, other than we know it when we see it?
My request is reasonableness and logic. And fortunately, that's exactly what the district court held. It seems like the best definition may be that if a driver engages the engine and the transmission to effectuate and spin the tires, that is operating a vehicle.
Oh, so that was my hypothetical about tinkering in my backyard. So I'm guilty. The car's up on jacks and I'm spinning the tires.
Well, guilty is a term used in the criminal context.
Okay,
and
well,
could
I've
absolutely be
violated the statute.
Correct. But the other things that the court had looked at was the implied consent law it's a civil penalty, and it's supposed to be construed liberally for the safety of the public, et cetera. And that was one of the factors that they looked at, was what was the safety of the public at that time? Generally, whenever there's an attempt case, like in Kindle, the guy was passed out, car was in neutral, it wasn't going anywhere. And all three of these criminal cases, the person was asleep. And in those cases, there's only a few steps that the driver has to take in order to put the public at danger. They have to wake up, they have to put it in gear, and they can cause problems.
It's the difference between this scenario and Justice Steagle's scenario, that he didn't have the intent to go anywhere. He's working on his car versus Ms. Jarmer maybe had at least the intent of getting out of the ditch. Is that a difference? Do we look at that or not?
DUI law has been pretty clearly established that intent doesn't really matter.
But, yeah.
It doesn't matter if you meant
Right.
drive impaired.
Right.
If you're impaired and you're in control, that's what we're worried about. Because we're not worried about, honestly, we're not worried about what you're doing. We're worried about the safety of the public. And when Miss Jarmer was doing what she was doing, the public was already in danger. She was taking all of the actions to put people in danger. The second that that thing gains traction, she's on the road and she's going against traffic. If, unfortunately, the car slips backwards, her husband's under those spinning tires.
Was there any evidence that supported either of those conclusions?
Oh, as in the direction of the vehicle?
No, just that the vehicle.
Oh,
could
these
have-
hypotheticals.
Could have jumped forward onto the road or could have slid backwards.
No, Your Honor. It was in the ditch, and as they said, that was the intent, was to get it out. But no, that there was no questioning or testimony regarding those issues. Appellant does take issue in its petition for review against some of the out-of-state cases that were mentioned. Again, those are not binding precedent. Those were simply analogous cases that wanted to see if the logic and analysis was congruent.
I have two questions. First, I'm briefly looking at the Court of Appeals opinion again, and it said that when they arrived, the tires were spinning. Was that in the factual record? The tires were spinning?
Yes, Your Honor.
Okay,
But very much so. It was honestly just so sloppy, muddy, and cold that there was no forward propulsion.
okay,
That
so the
the
tires
officer
are
said.
spinning. And also the very last paragraph in the Court of Appeals opinion cites to RK State v. Moeller, which is in the context of the Kansas Offender Registration Act. And it looks to the common meaning of the word as defined by Merriam-Webster's operate to mean bring about, affect, to cause to function or work, to put or keep in operation. And they say, using this definition, we agree with the district court's finding that Jarmer operated the vehicle. What is your position on that?
The appellant also took issue with the reliance on Moeller and Mr. Webster's definition. Again, that was yet another example that they used to bolster and affirm their already established conclusion, that they had made their decision.
What is your position? What's the state's position on that? Using that common meaning of the word?
Unfortunately, and generally, dictionary definitions are quite broad. I looked up drive before we got here, and there's a lot of different drives. There's golf drive and football drive, and honestly, those don't go an inch. But I don't think that we should adopt that as a bright line rule. I don't think that there should be a bright line rule for operation and movement. Whenever these cases, these very, very rare, very specific cases come up, leave it to the district court to decide. Was there movement of the vehicle? It is for these reasons, Your Honor. Your Honors, I greatly appreciate you taking this case and reviewing the issues of operation under the implied consent law. Defied appellant's assertion, KDOR does not wish to destroy the definition of operation as established in Darrow and other cases, but rather fulfill and clarify it. I pray that this court apply reasonableness and logic when considering operation and uphold the district court and appellate court's rulings.
Questions? Thank you. Karen, your reserve 3 minutes.
I just want to touch on briefly, Your Honors, the statement that council made in regards to what he believed that the legislature's intent was for making this distinction in the civil code. And the example that he gave was a person who has had too much to drink and goes out into their car to sleep it off. And what I would argue to this court is that's neither operation or attempted operation. They're claiming that would be violative of the statute. I don't think that that is. And I don't think that that is because of the language in Darrow that says that actual physical control is not enough for operation or attempted operation. There has to be some attempt to make the vehicle move to even have an attempt to operate. So at that point, that vehicle is just shelter. That doesn't make any sense to me. So I just wanted to clarify that briefly. And then in regards to, and this was brought up also, the cases that were cited, the out of jurisdiction cases that were cited in the Court of Appeals opinion, in both of those cases, the states that we're dealing with were actual physical control states. So when those courts are finding, and I'll admit that the facts are very, very similar to this case where somebody's stuck in the ditch and the tires are spinning. And in those courts, yes, they found that's operation. And the reason that they found that that's operation is because in those states, actual physical control is operation, which we don't have here. So I don't think that those
Council,
opinions are.
if I can jump in, I'm going to ask about one other hypothetical that comes to mind. And if we apply the rule that you are asking us to apply, the Darrow, Collison rule, et cetera, that when you're stuck in the ditch and spinning the tires, but you're not moving, you're not operating. How can you distinguish that, or is there a distinction between that scenario and a different one, which I think is plausible to imagine and seems to me to be obviously dangerous? And that is the drag racing type scenario where you're at a stop, it's fast and furious. You're at the stoplight, you have both the gas and the brake engaged. You're burning rubber, but you're not moving. How do you distinguish? I mean, I'm just thinking in terms of the rule and the outcome. The rule would applied the way you want us to apply it would suggest to me that that person is not operating the vehicle.
I understand the court's question. I guess the way that I would answer that, Your Honor, is I think that circumstance is different.
I know, but how? Under the rule, how is it?
I think it's different because the reason that the vehicle is not moving is also under the control of the person. I mean, in that circumstance, you've got to have your foot on the accelerator and your foot on the brake. This isn't a situation where the vehicle is broken or you're stuck in the mud. I mean, you're trying to drive, but you're failing. In that circumstance, you're intentionally not letting the vehicle move. I think there is a difference in that. I understand the court. I don't know what the answer is. I understand the court's question. We would ask Your Honors, Miss Jarmer, we fully admit she attempted to move the vehicle. She tried to drive but failed. Under the definitions provided by this court, we think that's attempted operation, and that's what we're asking this court to find. Thank you.
Thank you. Thank you to both counsel for your arguments today. The court will take this under advisement. I'll explain that by that, what we mean is that later today, the court will conference this case. And at that point, or hopefully at that point, if we get to that stage of our conference, a justice will be assigned to write a draft decision for review by the other justices. That review will continue until we reach agreement on the outcome of the case or have all of our separate opinions written about that, at which time it will be published. When it's published, it's put on the kscourts.org website. So anyone can read that and any of our other cases that we decide. And we also have a news release that announces the filing of the case so that people who are interested in a case can follow that. So with that, thank you, counsel, for your arguments today. I'll now call the second case on the 9 a.m. docket, 123687, State of Kansas versus Joshua Sinnard.
Morning, Your Honors. May it please the court, Corinne Gunning, appellate defender appearing on behalf of Joshua Sinnard. Madam Chief Justice, I would like to reserve 3 minutes for rebuttal.
3 minutes is granted. Thank you.
For the reasons that I've stated in my petition for review, I would request that this court vacate Josh's conviction based on the speedy trial violation, or on the alternative, reverse his conviction and remand for new trial errors. Josh maintains that the problems in this case started well before the trial, with the speedy trial violation. The state's attorney and the court seemed to be pretty clear early on that there was a particular case that took priority in their minds, and they worked to make that case a priority at the expense of Josh's statutory speedy trial rights.
What's wrong with that? I mean, if you've got multiple cases, you've got to prioritize one over the other, right? And the district court explained its rationale for doing that. I guess, how does that implicate? I understand how it could implicate the statutory speedy trial timeline, but in terms of the crowded docket exception being invoked, I don't see how a district court's decision on which cases get set, first, second, third, whatever, undermines the crowded docket exception that was invoked here. Can you help me understand that?
I certainly will endeavor to try. The position is that I fully understand the reason for the crowded docket exception. I recognize the trial courts are very busy. They have lots of cases set, and they do have to balance their docket a little bit. What I take issue with in this case is that aside from a couple mentions of it, it seemed that nobody was really concerned about Josh's speedy trial rights. We have 180 days. It does feel weird to be arguing about speedy trial at this time, but at the time, there was 180 days in which the court had to bring someone to trial if they were out of custody. Many of the people that we were talking about in their cases today are out of custody. Both Mr. Ross and Mr. Sinnard and Josh were at the end of their 180 days. I would expect that we would be talking about, okay, how are we going to set this so that we can respect both of these people's speedy trial rights? Josh was willing to waive 9 days. I think we would be in a very different position if he hadn't made that waiver. But he was willing to waive those 9 days to go to the October 28th date. Already at the end of his 180 days, he went to 189 days, and they still set him second. And then when Jordan Ross comes in and says, I don't have my client, my
Can I stop you there? So at that point in time, when he gets set for October 28th, the second setting, he was the second setting because yet another case was already set on that date, right?
Yes.
Was that like the Potts case or something?
Yes.
Like that? Okay. All right. I just wanted to make sure. So your second setting there, do we know what happened to that case?
I am not certain it did not obviously go on October 28th. That was when the Ross trial went. So I do not know what happened with that.
And if I'm hearing you, your real objection is that whatever happened to Potts, it went away, rather than moving Mr. Sinnard up to the first slot, they put the Ross case into that first setting.
Putting Mr. Sinnard functionally third on that day on his past his 180th.
Or second.
Potentially, yes.
Yeah, which was where he was originally.
I do know that Mr. Potts did not plead before that day. His case was not resolved before October 28th. But within this, I just feel within the crowded docket exception, I recognize the need to balance these very busy dockets. When the court moved Josh's case, contrary to what the Court of Appeals said, it wasn't to accommodate the parties, it wasn't to accommodate witnesses. Jordan Ross also was willing to waive his speedy trial date into the first part of 2020. All of this happened at the end of 2019. He was willing to waive his speedy trial rights into January, February 2020, which Josh had indicated he was not willing to waive. And so I think that also puts us in a different posture when we have two people at the end of their speedy trial rights. How are we going to balance that? Well, we have one that's willing to waive, one that's willing to not
Is that,
waive.
where is that in the record? For some reason, I didn't see that.
I added the transcript of the hearing that Jordan Ross had. I believe it is volume 30.
Okay.
Isn't it appropriate for the judge to balance more than just the wishes of the defendant as to when he wants to be tried? I mean, there are witnesses, there are schedules, experts that might be coming in. All of those things can properly be considered by the court, correct?
Yes, and I think that was something that the court looked at here, and all of the state's witnesses, all of the defense witnesses were able to accommodate a later date besides that October 28th date. In fact, defense witnesses, the defense expert in this case, Mr. Overstreet, he said, well, she has conflicts that week. I guess we can try and work it out. And Mr. Overstreet himself said he wasn't going to be available the first day of that trial week. And so the way that the balancing looks is not that the court was trying to figure out how are we going to accommodate everybody in this case. It looked like, well, we have all the state's witnesses, we're going to go, even though he was aware that one, defense witnesses may not be able to be there. Defense counsel was not going to be there first day, one of defense counsel, and the client was willing to waive his statutory speedy trial rights further. So the balance did not seem really very balanced.
Wasn't the other case older?
I don't know exactly when it was charged relative to.
Are we applying an abuse of discretion standard?
Yes.
And is your position that abuse of discretion was violated because of a legal error or because reasonable people wouldn't agree with the trial court's decision?
My position is that both. I don't think it was a proper application of the crowded docket exception.
And what's the rule of law that was violated? What was the legal error in a capsule? Really, the way that I've stated in my briefing petition is that when a court creates the crowding, which is what happened in this case, the court created the crowded docket. It wasn't a situation where, okay, like we come and we've got 3 cases set. It's, I know that these 2 cases are set. I'm going to set one ahead of those. When the court creates the crowding of the docket, the crowded docket exception is not appropriate for them to apply.
Your argument is it's a manufactured.
Yes. Yes.
And I guess I'm still having trouble, and I don't mean to interrupt your questioning, Chief. How is it that it was manufactured? The court has so many cases. They are all set for jury trial. How is that a manufactured crowded docket kind of exception, kind of creates the crowded docket and kind of does, I guess I don't understand that when 5 cases are set, and those of us that's been there, that's the reality. You have so many cases and you set them and try to work them through.
Yes, and it is, again, I really do appreciate the position of district courts, and particularly I know that trial counsel are trying to work through things on a regular basis, but typically Josh in this case knew he was going to be second up on that day. His counsel was going to be ready. He was ready to go on that day. Then he gets a motion to change his trial date. And without him being present, they've moved another case ahead of his. And so typically in district courts, I recognize that we have this, but they know that they're going to be, I'm third up, I'm fourth up, I'm probably not going to go. When you are third up versus fourth up versus first up, it changes your trial preparation. He knew he was going to be second up, possibility he was going to go. Without his presence, they moved another case in front of him and said, and, the judge was told, you can probably, just use the crowded docket exception once we move Jordan Ross. And that, I think that's my biggest problem in this case is, and I know that Danny Queen's case was very different, but what happened in that case is they set Danny Queen's case outside of speedy trial time, said, is everybody on board with this date? And then when they realized it was out of speedy trial time, they said, oh, but we'll go back and we'll find a reason for why we moved him past that date. And again, the circumstances are perhaps dissimilar, but in that case too, the court had a crowded docket. They had a busy docket, and then those are the dates that worked for them. It just happened to be past 180 days. In this case, they had a crowded docket. They moved another case in front of Josh's case and then said, oh, and now we have a crowded docket on that date that we're going to use to move him again. And so it feels like the court is looking for reasons to justify the decisions that it is making in prioritizing its cases, rather than saying, okay, we all show up on October 28th. This case is going to go. These other cases, we'll see how fast this case resolves. It was a week-long rape trial, so it probably wasn't going to resolve quickly, so that they could do 2 cases that week. But it wasn't a typical crowded docket situation that I think most district courts see. And I think
For clarification, because I'm not as familiar with the record as you are, was Mr. Ross in custody?
Ross was not in custody, no.
Mr. Sinnard was not in custody either.
So both of them had that 180-day clock, and both of them, frankly, were at the end of it.
Basically, it's your point that the crowded docket exception was utilized after they realized they said it that violated the speedy trial. That's basically your point.
Yes.
Thank you.
Can I
And-
ask you then, I'm sorry, I don't want to close up your arguments on speedy trial, but I did want to ask about the evidentiary objections too. So am I interrupting your closing on that?
No.
Okay. So we've released the decision in Timley, all right? And I'm sure you're familiar with that decision. What differentiates the testimony here? Well, I'll tell you what I think makes it different is at least there was some discussion about how cell phone towers connect with cell phones essentially here. But I don't want to put words in your mouth. I'm trying to understand what specialized knowledge really converted the detective's testimony from lay to expert, in your opinion here.
The way that I understand the court's opinion in Timley, kind of following other courts, is when a detective says, okay, here's where the cell phone connected, here's the towers. If you read cell phone records, we can see the towers they connected to. We can map where that happens and find out where the cell phone was relative to whatever incident happened in the case. And that doesn't require specialized knowledge because it's just mapping, it's just showing where things are. In this case, the detective testified about why cell phones connect or don't connect to certain towers. He testified about IMEI and IMSI information, which I believe is specialized knowledge about how cell phones work and what they do. He testified about particularly as well, why Josh's cell phone didn't connect to a tower for a period of time. So it connected this time and then the cell phone didn't connect to any towers. And so he explained why he believed it didn't connect to any towers. So he was giving specialized knowledge about how Josh's cell phone works and why it would or wouldn't connect to particular towers, why it would or wouldn't give a signal, which is more than just saying, okay, here's where we saw him at this time and here's where we saw him at this time. He did give both pieces of information, I mean, clearly, but I think he went beyond what this court said was appropriate in Timley for lay testimony.
Questions? So your position is that the speedy trial docket consideration must be the last arrow in the quiver and not just one arrow or tool that the court considers?
Yes, I would say that. It's the court's obligation to bring someone to trial within the speedy trial deadline. That our legislature had set a speedy trial deadline. Courts are required to bring them to trial within that time. And so I think that should be the court's priority. Balanced with their docket, but the priority should be respecting the rights that are set forth by the legislature.
Is that in the statute? The last,
I would no, the statute sets forth the time periods, and then there's a myriad of exceptions to it. But I think the primary is you must bring the person to trial within 180 days if they are out. And then here are exceptions to that rule. So I would say, just as far as reading the statute, the primary consideration is the speedy trial time. Unless.
so you want us to make that law, that it has to be last as case law?
I don't necessarily think that the court needs to make a particularly bright line rule on that. Every speedy trial case is factually. And so in this case, I think the court can find that in crowding the docket and as manufacturing a crowded docket, they don't then get the benefit of the exception. So unless the court has other questions, I would again ask that the court vacate Josh's conviction and relieve him from any further liability in this case based on the speedy trial violation, or in the alternative, remand for new trial based on the trial errors.
May it please the court. Good morning, your honors. Assistant District Attorney John Simpson appearing on behalf of the state. Unless the court would otherwise direct, I'll probably focus on the speedy trial argument. And if there's time, touch on the expert. So I understand defendant is arguing there was an abuse of discretion, one, because there was a legal error committed, and second, because no reasonable person could agree with the district court's decision to prioritize Ross ahead of Sinnard's trial. Concerning the argument that there was a legal error, state understands the complaint essentially to be that legally the crowded docket provisions terms did not permit the district court the discretion to move Ross to October 28th. And then when Ross proceeded on that date, use the exception to reschedule Mr. Sinnard's trial to November 12th, particularly because Mr. Ross was willing to waive his speedy trial rights. And the state does not believe the crowded docket provisions terms are so narrow. By its terms, the provision provides that a trial court may extend the time for trial if, quote, because of other cases pending for trial, the court does not have sufficient time to commence the defendant's trial. Now, nothing in that language shows the legislature intended that as the defendant effectively suggests, that the other cases in question be limited to only other already scheduled cases pending for trial, or only other cases pending for trial wherein defendant has already asserted, wherein defendant has asserted the right to a speedy trial. And I would point this court particularly to the Court of Appeals decision in State v. Dean. That's at 42 Canap 2nd 32, pages 35 to 38, where they ruled that the provisions terms, or whether they recognize the provisions terms do not even limit other cases to only other criminal cases. And so in that case, the court held the trial court was permitted to use the exception to prioritize trying a civil case, which could have been rescheduled over the defendant's criminal case. Ultimately, the only limit the provision places on the type of cases which may support the exception is that their status be pending for trial. And the ordinary meaning of pending, according to Merriam-Webster Black's Law, is essentially that awaiting. So if the trial court determines that it lacks sufficient time to try defendant, because of another case awaiting trial, the crowded docket provision allows it to extend the time for defendant's
You're
trial.
saying effectively a district court that has a really complicated civil case with motions for summary judgment pending and has to produce a, I don't know, 100-page written order could use that as the reason under the crowded docket exception to postpone a criminal trial.
I believe the statute legally permits that. I think the hurdle for the trial court in that instance
It might be unreasonable. You might
would be
get,
that they would have to prove that all reasonable person,
but it wouldn't be an error of law.
correct. And so in this case, Ross, of course, was an other case. It was a waiting trial, and the district court obviously could not bring Ross and Mr. Sinnard to trial both on October 28th. So whether or not the defendant was on the October 28th trial prior to Ross, or whether or not the district court could have moved Ross's trial to a later date he was willing to accept, Ross was still another case pending for trial that left the district court without sufficient time to try Mr. Sinnard.
What do you make of the argument that I was reviewing from the appellant's briefing that if you just look, and this may be an error of fact, sort of fall into that bucket, but that there were in fact dates that the court acknowledged that the case could have gone to trial on August 19th or September 3rd. And I think that was communicated at the July 23rd hearing.
So I think in this situation, we have to take a step back. The speedy trial deadline originally was set to expire the October 19th. Defendant waived speedy trial from October 19th to the 28th. So under this court's case law, the state did not have to, the state did not have to justify bringing defendant to trial prior to that date. And in this instance, when the crowded docket provision was actually invoked by the court, those dates had already passed. The only dates that the court had available to look at that time were, November 4th, or sorry, October 28th, which obviously couldn't proceed on that date. November 4th, which was crowded by another criminal case. And then the first available date after that was the date he received, November 12th.
So at that July 23rd hearing, the district court was sort of helping the defendant make a knowing and voluntary waiver by explaining that you could have, hey, if you don't waive, this is what the calendar potentially could look like. But given that information, there was a waiver. So then those dates sort of go away.
Correct, Your Honor. So I guess briefly touching on the argument that it was an unreasonable decision made by the trial court. The Ross trial involved the only date the Ross trial could proceed. The only date the district court had, the 10 to 13 estimated witnesses for the Ross trial had available, including a defense witness who had a admittedly quite full calendar, could try Ross, was on October 28th or over 6 months later in February 2020. And in Ross, it was an older, I think roughly a year older criminal case. It was a higher level felony. It had already been moved twice. And the district court recognized that further delay put added stress on the minor victim in that case.
What about the argument that he was willing to waive speedy trial? I mean,
Well,
what do we do with that?
I think, well, again, legally, it's a non-factor. And I guess I would point to the current version of the statute, which obviously wasn't controlling at the time. But it lists six factors which the trial court should consider in scheduling trials in the context of the delay COVID has caused the courts. And only one of those factors is the assertion of speedy trial.
This was all pre-COVID, correct?
Correct.
Clarify. Thank you.
So turning to the expert testimony issue, I think the the Court of Appeals properly reasoned that Fleming, Smith Parker, two of its decisions, and this court's decision in Timley, suggested that under those cases, Detective Slifer's testimony required no specialized knowledge or expertise beyond that which he possessed.
He was testifying from the phone records, right?
He was testifying primarily, if not exclusively, from the phone records.
Did the phone records he have identify the cell towers? Like my phone records, I don't think do that, but.
So the records in this case identified the location of the servicing cell tower. They did not, as in Timley and either Fleming or Smith Parker, one of them, identified the particular sector of that tower, which the signal, so they didn't narrow it to location oriented to a particular.
Wait, so will you say that again? I'm sorry.
So we identified, the records identified the location of the tower that serviced the defendant's phone. They did not identify a direction that the signal was coming in to the tower from. So
But those records said, like, I'm going to use a layperson's term. The record showed which cell tower was pinging from his phone. Yes or no?
correct.
Okay. And so even if he hadn't testified, I mean, they could have looked at the records and said, oh, this pinged this cell tower, this pinged this cell tower.
Correct. And there were the records accompanying the records were a set of instructions that the cell service provider included. And those instructions laid out much of what Detective Slifer was explaining to the jury.
Did it explain why for periods of time the cell phone didn't connect to a tower?
So, not to interrupt, sorry.
Okay, no, go ahead.
So I think there's a distinction to make. The testimony that I think Mr. Senator is referring to was not an opinion on why his phone did not connect to a particular tower. It was a general statement about why there would be no records outside those contained in the exhibit. So the exhibit essentially, and this is what the exhibit itself said, includes information only for calls made, non-roaming calls, and for standard text messages. Any use of the cell phone or non-use of the cell phone outside that would not be recorded.
Help me here. Why doesn't that require some sort of specialized knowledge?
I don't.
As opposed to me up there testifying what my records say. It seems like this is, I know we're kind of in this gray area, but this seems to lean to me towards requiring some sort of specialized knowledge on the way cell phones operate, how they're received, what towers, what they do. Is that just common knowledge?
I'm afraid, well, first of all, I'm not probably an appropriate candidate to represent what the common man knows or woman knows about cell phones.
What do you?
But assuming, for example, that knowledge is not something the ordinary or layperson would just happen to know. The qualifications that the state established for Detective Slifer in this case provided.
I understand it. So were they trying to qualify him as an expert? He did have some specialized knowledge.
They did not qualify him as an expert to provide opinion testimony, but they qualified him to lay foundation for to contextualize the records themselves.
Go ahead.
Was the opinion or the testimony about the way that the technical ways that cell phones and towers interact, or was it about the records?
So his testimony was primarily about the records, but he made an unobjected to and an objected to general statement about how cell towers, cell phones and cell tower signals generally interact. And that statement was essentially one of fact, not an opinion. It didn't apply any principles to the records in this case.
I'm just trying to understand. A minute ago, I think you said that his testimony was that anything the phone does outside of calls and direct text messages is not captured in the records. Did I remember that correctly?
Correct.
That strikes me as an explanation of the records, not the technical side of how phones and towers work.
I believe that's a fair characterization, and I think that's, again, what was reflected in the instructions, explaining how to read the records.
And was there additional testimony that was about the phones themselves and the signals that go back and forth, or was it just about what gets captured in the records?
I don't believe there was any testimony about how Sinnard's phone, particularly how his particular phone connected to a tower. I think it was just the records say this tower serviced his phone. The detective never testified that the record showed the exact location of the phone. He never testified that particularly never testified they showed the exact location of defendant. He simply testified, this is the tower that serviced, and the trajectory of those towers aligns with the victim's testimony about where she was and when with the defendant.
Any,
Want to know whether the state has any preservation concerns with the arguments that are being made on appeal concerning the detective's testimony with cell towers versus the argument that was made to.
Well, I think the state does have preservation concerns. I think the Court of Appeals recognized that we're talking about only one overruled objection. And so to that extent, I think that's the only issue this court should consider. But I will recognize the Court of Appeals opinion was never expressed in saying, you know, we are applying the contemporaneous objection rule, only this issue is preserved. But again, it certainly recognized that the only objected to, only sustained objection was to one instance of Detective Slifer testifying about his earlier testimony about how cell towers generally, or how cell towers and cell phones signals generally interact. I guess I would quickly touch on the instructional error issue for the court. In this case, when this court assesses instructional error claims, it considers whether the instructions as a whole properly and fairly stated the law and were not reasonably likely to mislead the jurors. And the case that Mr. Sinnard relies on, Jackson, there the instruction included no mention whatsoever of the requirement that the state need to prove that defendant acted knowingly. And so with that instruction, the jury was necessarily left with the misimpression that to establish the charge, the state had only to prove particular acts were committed under particular circumstances, and not that those acts were committed knowingly. But here, the instruction not only gave the jury the elements about which acts and which circumstances the state needed to prove, but also stated the state must prove the defendant committed the crime knowingly. And so that instruction told the jury not only what conduct the state needed to prove, but also that defendant needed to prove defendant engaged in that conduct knowingly. And I think the distinction that defendant draws in the petition, you know, distinguishing between the enumerated portion of the instruction as the elements and the non-enumerated portion, that information is purely definitional, is not one the jury would make. You know, the jury was instructed, it was its duty to consider and follow all the instructions. It was told the state had to prove each of its claims beyond a reasonable doubt. And with respect to the state's claim that defendant committed commercial sexual exploitation of a child, it was told that the state must prove the defendant's conduct, the defendant committed crime knowingly. So I don't think there's any error here with the instruction. But of course, should this court find error, there's no clear error because the jury obviously was instructed that it had to find defendant's conduct was knowing. If there are no other questions, the state would just submit that the Court of Appeals correctly found that a properly instructed jury convicted Mr. Sinnard without relying on inadmissible evidence at a timely trial. Would ask that this court from the Court of Appeals decision, the district court's actions and Mr. Sinnard's convictions.
Questions? Thank you.
On my rebuttal, I would like to maybe take things in reverse order with the elements instruction. In this case, in the Court of Appeals decision, the court faulted appellate counsel particularly by saying that the instruction was legally inappropriate because it had a definition of the culpable mental state on the same page. I would maintain that the elements instruction is still legally inappropriate without that element of the mens rea included in it.
You need knowingly in number 1 and number 2 on that jury instruction, right?
Yes,
That's your argument.
yes, the argument is that it should be included as an element, not merely, the definition doesn't provide the element.
Well, wasn't that the very instruction the defense counsel proposed?
Yes, and I was before this court a few months ago as well with with instructional questions. The question is not whether or not he proposed it, it's whether or not in him proposing it, he caused the district court to make a different decision. Everybody was on board. In fact, the instruction that was given is what is in PIC. I maintain that the PIC instruction is legally inappropriate. I don't think that him asking for it enticed the judge to do anything different than it was already going to do.
Well, the standard pick didn't include the knowing definition at the time, right? So you can arguably convince the judge to deviate from pick.
You can, and it is common practice. I'm sure this court is aware of including the definition of the culpable mental state alongside the elements instruction. It is a different instruction within PIC, but the PIC instruction of the elements for commercial solicitation does not contain the knowing element. And so just by him requesting this, I don't think that he caused the judge to do anything else than it was already going to do.
But I guess the panel didn't address invited error, and I don't believe the state cross petitions. So does that limit our ability to address an issue like that, or?
My perspective is yes, that this court only has before it what has been petitioned. Obviously, this court can and does often go outside that. I would say with the preservation concerns, I don't think any of the preservation concerns that the state raised below are also before this court. The Court of Appeals decided some of these, the questions on the expert testimony were preserved. They decided that there was no cross petition on the court's decision that those claims were preserved as well. So I don't think that any of the preservation questions are before this court as well. And with that, I see my time is up. If nobody has any. I would just ask again that this court vacate Josh's conviction based on speedy trial violation or remand for new trial.
Thank you. Thank you to both counsel for your arguments. The court will take this matter under advisement. The court will now be in recess for 15 minutes. We will resume court at 10:40.